Greetings, my fellow freedom lovers and sovereign thinkers. Thank you for tuning in to LO3 Podcast. My name is Craig, transmitting from the beautiful land of enchantment. And today's date is Friday, April 17th, 2020. Yeah, I just got this, observing some of the YouTube videos. And I subscribe to some interesting folks out there. And this one just caught my eye from Guns and Gadgets. And it's in reference to a lawsuit that the State Attorney General of South Carolina is suing the city of Columbia, the capital, the city of Columbia, for creating ordinances that contradicts the preemptive laws of that state. I'll give hats off to them. That's a good site. Go check out Guns and Gadgets. I think they have gunsandgadgets.com or .org. I'm not so sure, but they have it on YouTube. Just look up Guns and Gadgets. I will post a video on it on my Spreaker page as well, so you can go. All you folks out there can check it out. And I haven't really done anything when it came to firearms. Once in a while I do, and people know where I stand when it comes to natural rights. There's no compromises by any means. So I'm going to be going through some of the ordinances that actually occurred on 2019. And I'm not going to read it in its entirety. But this one here, this ordinance on 2019-46, it was considered a nuisance, okay? And I like when you use environmental health and sanitation, nuisance, all right? So, what this here is pertaining to the ghost guns, okay? They don't have any what is it? A serial number. You can't have a firearm that doesn't have a serial number. Of course, there's federal gun law saying you can't take it off or deface it. But if it's assembly made, okay, they're saying this is a crime. So this is very interesting because I'm looking into this stuff and I'm just really just scratching my head. So this is under a nuisance law. And of course it talks about repair, replace, destroy and all that, business days, citations and all that. International Property Maintenance Code. What the hell? That's more like a globalist entity, Agenda 21 conviction. But let me just see here. Ghost guns means a homemade firearm which was created or assembled without a serial number. So that's considered under nuisance, okay? You know what the difference between nuisance is? As used in this article, the following term shall have following meanings unless the context early indicates. And it's so cute so elegant how they make these things go away, about the nuisance. Abate means repair, replace, remove, destroy, or otherwise remedy the condition in question by such means, in such time, in such matter, and to such an extent as the enforcement officer or hearing committee shall determine to be in the best interest of the public, talking to all accounts of facts and circumstances. So they like to put this under nuisance as a ghost gun. You're a nuisance. And there's other things in here as well. But speaking of that is I like when I'm just looking through here. Yeah, public nuisance means as determined by enforcement officer based on facts and circumstances found after reasonable inquiry, investigation, or upon citizen report. Those conditions or events which constitute an unreasonable interference with rights of the general public. So if you have a ghost gun, and they consider it to be a public nuisance, but and they did this under 2, okay. I'll just read the public nuisance in its entirety one more time. Public nuisance means as determined by an enforcement officer based upon the facts and circumstances found after reasonable inquiry, investigation, or upon citizen report, those conditions or events which constitute an unreasonable interference with rights of the general public in general, and where in a public place or where the public congregates or where the public is likely to come within the range of influence through the senses of a person unlawfully does an act or omits to perform a duty, which act or omission does any one or more of the following. And actually says here, subsection 2, unlawfully interferes with, obstruct, or tends to obstruct or render danger for passage or any public, water, or public places, or way. Structure. So you can't really have something like this in the building. But I'm just like, wow. And it's very intriguing. So those guns are considered a nuisance, all right? But if you haven't used it on anyone, you just have it on you, it's a victimless crime in the city of Columbia, South Carolina. So those are the areas that you gotta question for sure, okay? But this is really interesting on that one. And it was approved, final reading was August 6, 2019, by Mayor Benjamin, his name is. Yeah, it's Eric Moon was the Erica Moon. Yeah, Erica's Moon. That's the Mayor Benjamin. That's so he's like something else here, you know. But those were the areas I just get a big kick out of. So ghost gun is a nuisance crime, okay, under this ordinance. And here's the next one here. But you can read the whole thing in its entirety. I'm going to leave it all in my footnotes. I'm going to give you the link. And I'm expecting to add, you know, the ordinances in there. It'd be for that year, but those certain areas. So it wouldn't be not hard to make it easy for you to look for it yourself. So I think that's important. And we got this one here, and 56 is under extreme risk protection orders. Okay, this is under the city of Columbia. All right, and that was done on the 17th of September. Right, it's been approved on the 16th or 17th. Right, I'm just gonna look up all the way down here. Yeah, the 17th of the final reading got ratified and all that. But it's funny about this one. It is when you look at this whole entire thing about the extreme risk orders, I like what it says here about findings and purpose. For the purpose of this article, the City Council does hereby find that 1. The first duty of government of the City of Columbia, South Carolina, is to protect their people. Really? So protect their people, but technically is not obligated under South Carolina Sovereign Immunity Tort Liability Act, right? So of course, 2. Gun violence and suicides present a public health and public safety crisis in the United States. Oh, really? And I like this one here. 3. A February 2018 Politico Morning Consult poll found that 76% of registered voters across America supported requiring that all gun owners store their guns in a safe storage unit. Okay, so safe storage unit. So it's like more like public safety. It's more like, you know, a personal safety and so forth. But they didn't say anything about here making it a law. And this one here says 4. Every year in the United States, on average, more than 250 children under 18 gain access to a gun and unintentionally shoot themselves or someone else. And nearly 600 die more by suicide performed with a gun. Well, how you know you saw that? Education. Under 18. Education. Safety. Is everyone's responsibility. Firearm safety is everyone's responsibility. And educating is fundamental. All right? I've used that rhetoric with statement with the Mayor Holness from Broward County, who was Commissioner Holness. So, of course, here 5, storing household guns, locked and loaded, or separate from ammunition is associated with a reduction at the risk of self-inflicted shootings among unintentional shootings by children and teenagers. Like I say, safety first. And an estimated 4.6 million is number 6. 4.6 million children and teens under 18 still lives in home with at least one gun that is loaded and unlocked, despite the life-saving effects that responsible gun storage can have. All right, so this is like, I don't know where to get these numbers from, But But one thing is here, it really dawns on me, is 7. Available evidence as complied by the RAND Corporation. RAND, R-A-N-D. They're a global institution, folks, okay? Where they hook up with the one-word order. Indicates that children access prevention laws, safe storage laws, reduce self-inflicted fatal or non-fatal firearm injuries among youth, and reduce unintentional firearm injuries or unintentional firearm deaths among children. See, you don't want the laws. It's the laws that's going to solve it. No, it's not. It's personal responsibility. Firearm safety. I could rant over and over and over again. And over 22,000 Americans every year, including 1,000 children and teens, die by firearm suicide. End. And here's the thing. They talk about psychotropic drugs. But I like it right down here. I like to use, I'm not going to go too crazy on this, but like it says here, 11, extreme risk protection order laws have been shown to help prevent firearm suicides, as shown by the empirical evidence of reduced suicide rates under Connecticut's and Indiana's laws. Are you sure about that? Only for firearms, but they can use multiple elements that could take their own life. And I can tell you people for a fact. All right, if you study suicides, SSRI cases, you'd be surprised. All right, and of course, I like to say it's here, extreme risk order laws as 12 can also prevent gun crimes. Oh, really? And examples of mass shootings from 2009 to 2017 revealed that 51% of instances the shooters exhibit warning signs that he posed a danger to himself or others before the shooting. And it's funny about that. Most of these shootouts that happen, especially at the schools and colleges, were in firearm-free zones. Leave all your security eggs in one bag. Leave all your security eggs in the hands of the government. And it's really funny here when the city council requires that South Carolina Code 23-31-15 restricts municipal regulation of transfer, ownership, possession, or transportation of firearms, ammunition, or components of firearms. That SE 23-31-520 denies a municipal right to confiscate a firearm unless an incident to an arrest. And this is so you can go down here on 14. City Council also recognizes its responsibility to respect governing law and thus may not impose a prohibition of transfer, ownership, or possession or transportation of firearms, ammunition, or components of firearms until governing law allows it to become effective. And even though the proposed statewide protection law was introduced, but the city council, the city council called upon the South Carolina General Assembly to protect all South Carolina by enacting statewide extreme risk protection order. All right, and it's funny about this. They're like, we believe you, but this is how we're gonna look at it. And when you go a little further down on this page, it tells you what the definitions are on here. And the preliminary matters is really more mind-boggling here with 14-354 on preliminary matters, and it talks about individuals have standing to file a petition to extreme risk order or renew an extreme risk protection order by a law enforcement, household, or family member. You don't have to pay a fee, maybe charged on this article. And it goes about extreme risk order is effective at the time of service. The respondent on this article shall have the right to be represented by counsel. Oh, how nice. If respondent can afford an attorney and meets the income guidelines applicable to representation by a public defender in a criminal case, the court shall appoint counsel upon a request of the respondent. So they're being nice here. All right, so it's like a civil case. That's what comes down to it. And of course, around here on 14.355, the petition to an extreme risk order. The petition for an extreme risk order shall set forth facts that demonstrate the risk presented by the respondent's ability to purchase firearms or have possession or control of firearms. It shall describe the numbers, types, and location of any firearm known. So it's a right of privacy. I'm going to get all through that, okay? Control. And of course, it says here about the extreme risk order. At the time of the filing, should also identify all known restraining orders, orders of protection, pending lawsuits, complaints, petitions, or actions pending active or filed within 1 year to petition for an extreme risk order involving the respondent, including but not to limit it, an order pursuant to South Carolina Code 20-4-10. All right, and now just going down here, as I see about the court may consider all relevant evidence, but no case shall order an issue under this article relating to an interim extreme protection order or relating order after a hearing absent a demonstration of risks due to behavior or events occurring in the preceding 24 months, so like the last 2 years. And what they determine on this are the following factors and the recency of any behaviors or events: suicide threats or attempts, threats or acts of violence or attempted acts of violence, domestic abuse, including any violation of a protection or abuse order, all right, cruelty to animals, abuse of controlled substance or alcohol, or any criminal offense that involves substance or alcohol, unlawful or reckless use, displaying, or brandishing of a firearm. So what's that got to do with the extreme risk protection order? See, certain cases like this, those are considered charges. Those are criminal cases, but they're trying to do this whole put the pressure, put the anchor, put the burden on the accused or the respondent. And I go on here, recent acquisition or attempted acquisition of a firearm, or possession or use of control of a firearm as part of a respondent's employment. Any additional information to the court to be found to be liable, including a statement by the respondent. So these are like, I consider, it's like technically this whole thing is really confoundedly dangerous. And of course here about the court reviewing, I'm going to go down about the risk protection finds by preponderance of the evidence that the respondent presents a risk of suicide or cause of death or causing bodily injury, another person, and the risk is imminent, and other circumstances that will bring a safe proceed by ordering hearing on this article to the hearing on a petition issuing an extreme protection order do not exist. So it's interesting about the interim. It tells you about the date an order was issued, instructions for reclaimment of any firearm or firearms license that a respondent own, that is in the respondent's possession or control, notification of the penalties for violating the order. So if you don't honor it, you may go to jail. So look at that, double whammy, like what happened in Florida with that one gentleman in Broward County. I might have to do a little homework on that as soon, when I have that chance. So when I go back there, I might do a little homework on it and do a show, because I am not too pleased with what's been happening. All right. And of course, they want to try to do this whole due process thing in a more lighter note, make themselves so eloquent. And of course, those are the right to request a continuance, and instructions of requesting continuance or waiving of the hearing. All right, and those are the right of an attorney on this article relating to preliminary matters, the cabinet attorney. But it just doesn't make any sense. This whole thing is a civil thing, and of course, they talk about the petition on here, which is very, very disturbing as well. I'll go about here. Upon reviewing a petition on this article relating to the petition to the extreme risk protection order, the court may issue an order for a hearing on the petition, which shall be scheduled to be held no more than 10 days a day of petition. But notice the law enforcement and they talk about here about the risk order of hearing, order reviewing, vacating, or terminating extreme protection or risk order shall cause a copy of this order to be delivered to the local law enforcement agent in the South Carolina provision. Okay, that's one of those things about if it goes up or down. But B, upon receipt of an extreme risk protection order or an order reviewing, vacating, or terminating extreme protection risk order, the City of Columbia Police Department shall advise the South Carolina Law Enforcement Division and request or cause the South Carolina Law Enforcement Division to enter the order into appropriate database, and a notice of the order is provided through the South Carolina Instant Check System, all that. And of course, we hit here on services, which is 14-39. And it mainly Talks about a hearing shall be made in person by a law enforcement officer as directed by the court issuing the order. At service time, the law enforcement officer shall provide a respondent with a copy of the petition. And immediately upon completion of a service, an extreme risk protection order, law enforcement officer completing service shall make a return of service to the court and shall provide a copy of the return of the petitioner. And then you talk about the orders of the hearing and the termination of the hearing. A respondent is subject to may request one request, renewal. All right, and it gives the whole thing. But it comes down here, their so-called version of due process on evidence so forth, relinquishment of firearms. This is actually 14-363, an extreme risk protection order issued on this article relating to the interim extreme risk protection order or relating to order after hearing shall require the relinquishment of all firearms owned by the respondent or in the respondent's possession or control within 24 hours following service of the order, except for the cause shown, in which case the court issuing the order shall specify the time for relinquishment or any of all respondent firearms and notify the subject to order that he can relinquish the firearms to a licensed gun dealer that is willing to take custody of the firearms or to local law enforcement. So this the respondent can relinquish it in two areas. So it's going to give the dealers a hard time on this, okay? So I'm going to continue on here. I would just B of this. If a law enforcement officer serving extreme risk or shall request that all firearms and any firearms license in response possession or control be immediately relinquished into the custody of the law enforcement officer. So one governmental delegate to another, right? Law enforcement officer taking custody of a firearm or a firearms license under this article shall transfer the firearms or the firearms license to the Columbia Police Department property and evidence facility for safekeeping. Yeah, right. You think I'm going to really buy that hype? Have a governmental institution hold my firearms on this ludicrous matter. And of course, I give the whole rundown about the affidavit, name, date of birth, social security number, all the firearms and miles and serial number, license number, and all that. And acknowledgement. This is interesting here about number 6. An acknowledgement that the firearm, if sold or transferred, will be sold or transferred in compliance with state law, that no firearm will be returned to a respondent or any third party until the dealer has independently confirmed that the person requesting return of a firearm is legally eligible to possess firearms under federal and state law. So if you're considered a convicted felon, it may be different. But let's see what it has to say here about the return of firearms. Subject to this article, if following the hearing court vacates the interim extreme risk order, the court shall order the immediate return of all relinquished firearms and licenses to the respondent. Upon termination of expiration of an extreme protection risk order, the respondent may request a CBD return the firearm or license that had been relinquished. All right, and of course here there will be no. On the article, the dealer shall return the firearms as soon as possible, but no later than the next business day after the day which the respondent makes a request. And a third party requests the return of a related firearm at any time, providing proof of the ownership and sworn affidavit. The proof of ownership may consist of the statement in the affidavit. The affidavit shall affirm the following. It says here, the third party will not intentionally or knowingly return a firearm to a person subject to an extreme risk order, nor intentionally or knowingly allow a person subject to an extreme risk order to have the access to a firearm. And of course, the third party understands that intentionally or knowingly allowing a person subject to an extreme risk order to have an access to a firearm constitutes a violation of the CERC article, shall be guilty of a misdemeanor, okay, under 1.5. So it gives you a whole thing about this and about the third party will be stored in the gun safe, which does not have will not be permitted to access or in a location outside the home to which a person doesn't have access. So, and of course, it says here about 3C, prior prior to returning a firearm to any person, law enforcement agency, or firearms dealer in possession of the firearm shall independently confirm that a person requesting a firearm is legally eligible to possess the firearm under federal and state law. The law enforcement agency or dealer receiving a request under this article shall conduct a required background check as soon as possible. So, but no later than next business day. So, and even around here, they talk about the abuses, okay? That's considered a misdemeanor, okay? About person, this is 14-3365, section, okay, abuse of process. A person who files a petition for an extreme risk order knowing the information in the petition to be materially false or with intent to harass another constitutes a violation of this article and shall be guilty of a misdemeanor. Not a felony, but a misdemeanor upon conviction. A misdemeanor for falsifying extreme risk protection order. Give me a break. And a person determined to have violated this article will be determined by the court have acted in bad faith for the purpose of harassing the respondent shall be ordered to pay full restitution to the respondent for the purpose of this article. Restitution shall include, but not limited to, reasonable attorney fees, costs, storage, and other expenses incurred by a respondent as a result of the false reporting or false swearing. So, but you still get technically a slap on the wrist. You may get restitution, but it's just a minor offense. Okay? This is how half-assed this really is. Okay? And it even talks about the violations on here. Alright? Penalties for violations. Anyone that fails to it is guilty of a misdemeanor as well. So it's just pretty damn ludicrous. And like it says here, the article shall be interpreted to consistent with any legislation enacted by the South Carolina General Assembly. Well, so far what I got here, it is pretty damn invalid, okay? A negated ordinance for sure. And so we're going to do one more here, which is 63 of Ordinance 2019 about schools, gun-free school zones, and it talks about distancing and components of firearms. Okay, local gives you authority. Local government gives you the authority to put gun-free zone ordinances into effect, which I don't really get it. So it's like a 97 thing. So that may be a little bit of a challenge, but the fact is this, folks. So the state can nullify that. The Omnibus Consolidated Appropriations Act 1997. Okay, so they recognize this on restricting, but they believe Gun-Free Zone Act of 1990 has amended the adoption of Section 657 of the Appropriation Act of 97. Local governments are given the authority to put gun-free zones ordinances into effect. Well, like they believe, they're trying to tell you that federal law supersedes state law. If it was repugnant to the U.S. Constitution, it's void. So, and of course, under they could talk about the whole thing here about in conjunction with South Carolina 16- possession of firearm school property. Yeah, okay. Carrying a weapon on school property concealed pursuant to federal law. And it's funny here, none is about the federal law, which is 18 U.S. Code Section 922Q3. Nothing in this subsection shall be construed or as preempting or prevent a state or local government from enacting a statute establishing gun-free zones as provided in subsection. The city council adopts this gun-free zone, school-free zones ordinance. So it'll be more of a challenge in that one too. So how I look at firearm-free zones in schools, hey, look what happened to some of the places from, I could say, at least from 90s and now, okay? And if you heard my shows in the past, I call these people out all the time, including Columbine, 9/11, Virginia Tech, Stoneman Douglas, even Sandy Hook. What they'll have in common, these institutions were in where? Firearm-free zones, including the horrific incident that happened at Pulse nightclub in Orlando, Greater Orlando area, and of course Fort Lauderdale Hollywood International Airport. That was a firearm-free zone by law as well. So it's more of a federal encroachment okay, these particular laws. So I have to disagree with that because 45 and 46 of Federalist Papers, James Madison warned us about these things. And of course, tells you about you can't have a firearm within 1,000 feet from the grounds of a public, parochial, or private school. Okay, and prohibition against possession or discharge of a firearm in a school zone shall be unlawful for any individual to possess a firearm at a place that individuals know the reasonable cause to believe is a school zone. All right, so locked in a container, locked in a firearm rack, which is in a motor vehicle. So you can have it. Oh, let me see here. Prohibitions. Right, shall not apply. Okay, so you can have your firearm in your glove compartment. You can put in a box in a glove compartment. That's fine. But there's some sketchy things about this. Okay, and this is why I'm looking at this. Guilty of a misdemeanor as well. So technically, it's more. Some of it is more of a firearm-free zone or victimless crime law if you have it 1,000 feet from the schools. And so it's really just disturbing. And of course, there's a lawsuit filed by South Carolina's Attorney General Alan Wilson, because he believes the ordinances are seeking a declaration. The 3 City of Columbia firearm ordinances are unconstitutional. So it's more than a little. So what's going to expect the City of Columbia use one of these ordinances as a federal gun-free zones where you have to comply with that, and legally you don't. And so what's here talking about here about when you talk about governing states and Constitution. It says here South Carolina 2023-31510 provides a pertinent parts as follows: no governing body of any county, municipality, or other political subdivision in the state may enact or promulgate any regulation or ordinance that regulates attempts to regulate, transfer, ownership, possession, carrying, transportation of firearms, ammunition, components of firearms, or any combination of these things. And 23-31-520 further states the article does not affect the authority of any county, municipality, or political subdivision related to the careless and negligent discharge of public brandishment of a firearm during the time it was demonstrated potential for insurrection, invasion, riots, or natural disasters. This article denies any comedy to any county, municipality, or political subdivision the power to confiscate a firearm, ammunition, unless an incident of an arrest. So it says here, 6, the Second Amendment of the U.S. Constitution provides the right to keep and bear arms shall not be infringed. And to be very frank, the Attorney General should add Article 1, Section 20 of their state constitution as well. So, and he's calling out the thing on ghost guns and being a public nuisance, and even around here about the extreme risk orders. And this ordinance allows law enforcement, family, hold members seek an order requiring the relinquishment of firearms by individuals found to be a risk by the court under the terms ordinance. And of course, 2019-63 criminalize the possession of a firearm at a place that individuals know has a reasonable cause to believe in a school zone, which is defined ordinance on the grounds of public, parochial, or private school with a distance of 1,000 feet from the grounds, public, parochial, and school and private school. So, of course, the Attorney General had opinions of the allegations regarding this. He talks about an opinion on the emergency ordinances for temporary ban of weapons within 250 feet area surrounding South Carolina State House grounds. All right, in his state, we believe the court will conclude Columbia ordinance can treat state law as well as the Second Amendment. You got to use the state constitution as well, but I will explain this because I see some of these ordinances does contradict South Carolina's constitution. And so of course, so the 2 ordinances were subjected of an opinion. So a lot of it here is mainly just viewpoints and so forth. And of criminalization, of course, and ghost guns, victimless crime laws. So the whole thing is all in here. And first calls of action, of course, Stephen Benjamin, strongly urging the orders. He, on December 3rd, 2019, the Attorney General wrote to Honorable Stephen K. Benjamin, Columbia Mayor, strongly urging that the ordinances be repealed because they're inconsistent with state law and the Second Amendment. The officers did not receive a written response to the letter, but news media reported that the city respectfully disagree. No actions appear to be taken to repeal the ordinance. Well, so they want to do this whole cause of action. They got this lawsuit happening. And the second cause, too, to make sure these ordinances are invalid, period. And, yes, I'm gonna leave that on there, including those the local codes, which you can find it from their own state codes. When he had that complaint in there, so it does have merit. They do interact. All right, so this is gonna be a real exciting thing. But I can tell you this: these ordinances are unauthorized, period. And the tricky thing about it, when you start looking at their own state constitution, okay, when it goes Article 1, Section 3, let me hope for 3 first. The privileges and immunities of citizens of this state in the United States on this Constitution shall not be abridged, nor any person shall be deprived of liberty, life, liberty, or property without due process of law, nor shall any person be denied an equal protection of the laws. Okay, so it's like a temporary thing, so the whole thing is total like, hey, we need the money, let's take advantage of these people. All right. So that's under privileges, immunities, due process, equal protection of law. And one here on Section 4 talks about the ex post facto laws, impairment of contracts, titles, effects of conviction. No bill of attainder, ex post facto law impairing the obligation of contracts, nor law granting any title, nobility of heredity, amulet shall be passed, no conviction shall work corrupt of blood or forfeiture of estate. So this particular these ordinances does not impair, is an impaired contract. Okay, so we can just go on a little bit further here on 15, and 15 reads about right bails, excessive bail, cruel, unusual, or corporal punishment. All persons shall be before conviction be liable by sufficient sureties. Bail may be denied to a person charged with capital offenses or offenses punishable by life or imprisonment, with violent offenses defined by the General Assembly. So I'll just go down here to like the third sentence. Excessive bail shall not be required, nor shall excessive fine be imposed, nor shall cruel, nor corporal, nor unusual punishment be inflicted, nor shall witnesses be unreasonably denied. Oh, yeah, so we're going to hit 20, and 20 says it right here about the right to keep and bear arms. And it will be, because they have quartering troops in here as well, but we'll just hit this first sentence. A real regular militia, being necessary to cure of a free state, the right of the people to keep and bear arms shall not be infringed. And we can hit 23, provisions of constitutional mandatory. The provisions of the Constitution shall be taken, deemed, and construed be mandatory and prohibitory, not merely directory, except where expressly made directory or permissive by its own terms. So there's multiple violations of South Carolina's Declaration of Rights, including Columbia, the city government of Columbia. And we can hit Article 3. We'll look at 26 and 20. Now, I think 27 is interesting, but we'll hit the oath of office. Members of the General Assembly and all officers before they enter upon the duties of the respective offices, and all members of the bar before they enter upon the practice of their profession, shall take and subscribe the following oath. I do solemnly swear or affirm that I am duly qualified, according to the Constitution of the state, to exercise the duties to which I have been elected or appointed, and that I will, with the best of my ability, discharge the duties thereof and preserve, to protect and defend the Constitution of the state and of the United States, so help me God. And I was like looking at the removal of office, but it's mainly embezzlement. But it'd be a good ringer thrown here on section 27. Officers shall be removed or for incapacity, misconduct, or neglect of duty, and such matters may be provided by law when no mode of trial or removal is provided in this Constitution. And one thing I noticed too, I was like, there's no recall votes, if I'm correct, in the state of South Carolina, including on local levels. So it's mainly, like what I got here is mainly embezzlement. But I'm gonna go to Article 6, and I'll explain this a little bit more. Of course, they have their oath of office on 5 and 8 and 9. Let me see here. Boom. And the only thing is bad because when it says here on suspension prosecutor of officers accused of a crime, whenever it appears to the satisfaction of the government that probable cause exists to charge any officer or the state or its political subdivisions who has a custody of public or trust funds with embezzlement or the appropriation of public trust or funds to private use, then the government shall direct his immediate prosecution by the proper officer upon indictment by a grand jury. Upon a waiver of such indictment is permitted by law, the governor shall suspend such officer and appoint one in his stead until he shall be acquitted. In case of conviction, the person shall be declared vacant. So, and same thing down here with the whole officers of subdivisions, except members of any officers who have been indicted by a grand jury. So then right there, there's no recalls. That's the only time he can remove people from office or suspend them in those matters, but nothing like derelict of duty. But like I says here, officers shall be removed for capacity, misconduct, or neglect of duty, and much in such matter may provide by law or when mode of trial is provided in this Constitution. So that's like, you gotta question that. So it's pretty like disturbing in my eyes. I think that's why they're doing this lawsuit instead. But when you look at Article 8, Article 8 in this matter, and of course it hits Section 1, the powers possessed by all counties, cities, and towns and other political subdivisions at the effective date of this Constitution shall continue in change in the matter provided by law. So this ordinance does not coincide with the state constitution. And so we can hit 14, subsection 1. I'll read that for sure. And it says here, enacting provisions, which is general law provisions not to be set aside. Enacting provisions required or authorized by this article. General law provisions applicable to the following matters shall not be set aside. 1, freedom guaranteed every person. Okay? So, and we can hit, I'm just looking at this a little bit more. Okay, that's really it here. And I like here 6. I think 6 makes a lot of sense too. The structure and administration of any governmental service or function, responsibility for which rests with the state government or which requires statewide uniformity. Alright, so we just hit 17 on this one of this section. And 17, construction of Constitution and laws. The provisions of this Constitution and all laws concerning local government shall be liberally construed in their favor. Powers, duties, and responsibilities granted to local government subdivisions by this Constitution and by law shall include those fairly implied, not prohibited by this Constitution. So that's another challenge which the Attorney General can use. So those are the areas you have to question. And this is why I consider this to be unauthorized, period. And a good thing, interesting here too, if a lot of you folks out there, if you remembered with the whole Patriot Act resolution that was passed in 2005, if I'm correct. Yeah, around 2005. And I like it when it says here, approval by City Council, where the City of Columbia has a long and distinguished history of protecting and expanding civil rights and civil liberties as set forth in the U.S. Constitution and Bill of Rights, especially freedom of speech, assembly, and privacy, right to counsel and due process, and judicial proceedings. So I don't know if there's going to be any judicial proceedings with this whole ordinance. So it'll be more like so the person, the respondent, may not have a right for a jury. Okay, protection for unreasonable searches and seizures. So and it's so interesting about this. It's like, I'm like looking at here. It says here, whereas the city of Columbia is motivated to protect the human rights of all persons in Columbia and the free exercise of enjoyment of any and all rights and privileges secured by our constitutions and laws of the United States, the state of South Carolina, and the city of Columbia. Well, with these ordinances here right now, and probably many others, Columbia is doing is contradicting this this resolution. All right, and and it says here, the city of Columbia believes there's no inherent conflict between national security and the preservation of liberty, and affirms its strong support of the right of Americans to be safe and free. All right, it's made about the Patriot Act, and of course, you talk about nearly 400 cities and 4 states, and the National League of Cities have adopted resolutions criticizing the violation of the United States Constitution and Bill of Rights, as well as state constitutions imposed by the U.S. Patriot Act. So, and I like it says here about, therefore, we, the City of Columbia, enacting in spirit and history of our community, do hereby request local law enforcement, city employees to preserve residents' free speech, religion, assembly, and privacy rights to counsel in due process and judicial proceedings, protection from unreasonable search and seizures, and seizures in accordance to the solemn oath to preserve, protect, and defend the constitutions of South Carolina and the United States of America, which Mayor Benjamin and his cohorts are doing the opposite. Plain and simple. So this is under national security. But yeah, it came out in 2005. I looked into it. This is from the ACLU's website. It's great because you don't have to agree with them completely, but a lot of the information they have, you can utilize it. Firearm rights and so forth. Conservatives can use this. Libertarians can use these things to counteract what governments on a local level are doing across the board. So this is why the ordinances here are null and void. And please, anyone that agrees with the city of South Carolina's decision, prove me wrong if you dare. Because the truth of the matter is, you have no merit. Convince me. You have to really earn it. So, I know I ranted, I did digress a little bit. I didn't really go too crazy. I tried not to go everything word for word, but I had to give you guys a whole rundown about these ordinances. And so, I think this lawsuit will be very interesting. And I encourage the Attorney General to use all these ammunition I provided here on my show. So I'll leave all the footnotes here, of course. So I'm like, thank you for listening. Plus, feel free to download and share us throughout the social media networks. If you have any questions, comments, or something interesting you want to check out, whatever you do, please send your correspondences with decorum. I'll repeat myself. I'm going to leave all these footnotes on my Spreaker page. Once again, thank you for your time. Plus, always remember that demoniac resistance is healthy for the soul and can liberate humanity. Until next time, take care of yourselves. Keep on spreading the love, and may your guardian spirits be with you.